Welcome, everybody, to the Loud Little Ducky. So, I am glad that I got a chance to be able to go live today. I really didn't want to wait until tomorrow after the hearing or before the hearing um, and speak on a few things. So, we are going to talk about them. We will get to Laura's new motions, but first, we're going to address some things. Um, and those things involve Laura Owens' former attorney, David Gingras. And so let me bring this up. All right. Actually, let me see if I can do something here before I bring it up. Let me see here. All right, let's do that. Mm. There we go. That looks good. Okay. So, for those of you that don't know, Congress made a post today. Um, I would like people to, if they go and view it, personally respect the way I present online. My channel is Loud Little Ducky. People can call me Ducky. Even people in my real life call me Ducky. That's my name for my grandson as well. So he doxed me, put my name out there, which I do not go by my real name online, as far as this stuff goes, and I keep that stuff private because there are crazy people out there. Not saying any of y'all are those people. People have been very respectful today, and my phone number, which please don't call me, um, unless you have permission to have my phone number. Um, you can contact me via Twitter, via Loud Little Ducky Instagram. You can contact me via email, loudlittleducky@gmail.com, and I will respond there. So I am just asking that y'all don't share that part out and just respect my private life because while, yes, I am out in the public, I my personal life has nothing to do with this except for when I bring it in, and I don't need people doing things or being crazy with it to my kids or to my grandson or anything, um, and it's just not okay. It's actually against the law, um, and you would think as a lawyer, you would know that. Um, I filed a bar complaint on, Gingras in Arizona and in California. Now, Arizona, let me show you this. Okay. I'm going to present because Gingras addresses this, and he doesn't exactly address it properly. Okay. So, on October 16th, 2025, I reviewed your October 15th, 2025 written charge submission regarding Mr. Gingras. As Mr. Gingras is admitted to practice law in the state of California, and since the pleading at issue in your charge was filed in court in California, and since this is an issue of which our office is aware, jurisdiction and venue would be more appropriate with the State Bar California. So, um, they didn't tell me to go fuck myself or that your complaint is stupid or this is not a real issue. They simply tell me to go to California. Says, while we would have jurisdiction since Mr. Gingras is admitted to practice law here in the state of Arizona, it would be better to raise your charge with the State Bar of California since the action occurred there and all pertinent witnesses and evidence would be there. You can contact the State Bar of California to file your complaint by visiting the following website. So they even helped me. If I hadn't already done this, they give me a link to go file it with them. They're just be and I thought that that might be the case, but I wanted to file it there because he is acting in Arizona, just was in a California case. And so I knew that this was a possibility, at least in Arizona, that they would tell me the filing happened in California, so that's where it needs to be submitted. And here they're like, "Go file it there." S Under Arizona rules of Supreme Court, should the California disciplinary authorities issue a disciplinary sanction against Mr. Gingras' license to practice in the state of California, Mr. Gingras is obliged to report that to Arizona's jurisdiction as well, and we could initiate reciprocal disciplinary proceedings. I have determined that further investigation is not warranted currently, and our file has been closed. And then pursuant and Matt McGregor is the one that dealt with this. So oh gosh, okay. No, I did not file a copyright because he filed a copyright strike on my channel. Um, and so but I was looking at laws, and I'm going to be looking even further. When you file a bar complaint and it gets dismissed or it's not being investigated, nothing's happening with it, there's no disciplinary action that happens with that bar complaint, it is confidential. And so I wanted to see if by him so-called doxing, if there was any legal action that could be taken on it because, um but I needed to make sure that bar complaints weren't public record. And the ones that are, like, up for, like, disciplinary and all that stuff, those are considered public, but because this was dismissed and closed and nothing became of it, this one should have been confidential. Now, I don't know if anything will ever, um, come of it. Um, I don't know if the people that he's on bail for give a shit about it. But I will be looking into that because the fact that he wants to complain and say that everybody else breaks the law and he doesn't is a crock of crap, and he needs to be held accountable. Alright. But no, it was not because he filed a copyright claim. Um, let's look at what he states in his stupid post. What happened here? Okay. Alright, let's share. Why are we talking about boatless in Seattle and Seattle's boats? What does Seattle have to do with anything? I'm so confused. Yeah, you can add me to that list, Bruce. I mean, I don't have any, so therefore, even one mugshot is more than me. Um, and that's another thing. If somebody went searching, they're not gonna find anything. Like, I don't behave like a criminal or I'm not crazy. I attempt to live a very vanilla life if I can because I don't like all that. But I will speak up. No, don't do that to Tom Hanks. Yeah, he is boatless. Boatless in Phoenix, which I don't know why you would need a boat in Phoenix. I mean, I guess there's lakes. Alright. So, Dingus goes on a rant. Why is this? Mm, okay, let's do it this way. Can anything done? It is a crime to dox people. Um, so, um, I will be looking more and acting more on that, um, later. Okay, so as an attorney, in his attorney capacity, he writes another blog post on Gingras Law Office, gingraslaw.com, called Bar Complaints Wiki, version 1. Alright. He wrote this October 20th, 2025. I wish it gave the time. I think it's funny that he cleared out a lot of stuff, but, um, anyways, he said, "Ever heard of the saying, 'If you don't have haters, you're doing something wrong?'" And he got it from brainyquote.com. I mean, you know I like my quotes. "Well, I guess I'm doing a lot right, as evidenced by the fact I keep getting more bar complaints, generally from total strangers. Don't ask me the total number, I've lost count." That is not a brag. Like, that is not a brag at all. That's so I have so many bar complaints for being a shitty ass lawyer, I can't even count. I'd like to create a full wiki page covering each one, showing the allegations and how they were resolved. Yes, mine was resolved in no further investigation and a dismissal because they thought I should go to California's bar and complain. This would be interesting and informative, but when weighing pros and cons, I can't justify giving that much free content to YouTube parasites. Let me stop sharing this for a minute. I have to mess with something real quick. Okay. Didn't realize he used it multiple times. For now, let's just talk about one recent complaint. This was from a person who I do not know named, and they give my name. Actually, I do not know. Oh my God. Why did he? Ugh, I should have looked fully through this. Good Lord. He could have at least said Ducky. This is annoying. He really, really repeated. Like, what, count up how many times he did this. Oh my God. Could you use my name anymore? Sorry, I'm just putting in this stuff. Jesus Christ. Y'all talk amongst yourselves. I didn't realize he was going to say this word so many times. Okay, I did that. Okay. Okay. All right. Sorry about that, y'all. Okay. He used my name uh uh so many times. Okay. We can even keep a tally if we want. All right. So this person was from who I do not know the name, Ducky. Actually, I do know Ducky, barely. All I know is she has a very small YouTube channel. Yes, under 1,000. Creeping to 900 and slowly creeping to 1,000, but not there yet, which also means I am not monetized and I make no money. off of anything on my website as of or on my YouTube as of today or as of the day I covered that he copyright struck me or the video where I used his workout selfie. All right. All I know is okay. A few weeks ago, Ducky posted a video covering the now denied and 100% BS motion to disqualify filed by Omar Serrato in Mike Maricini's San Francisco DVRO case. Because she is an unfriendly person, yeah, that's what it is. I'm an unfriendly person. Well, thank you, LM. I'm an unfriendly person, apparently. I am not unfriendly. I am actually now. If you cross me, you chose the wrong one. But if you're not crossing me, and I reached out to him, which he addresses here, and I've gone over. But he also says more stuff. 1, 2, 3, 4. All right. She's an unfriendly person. Without asking for permission, Ducky used a photo of me, selfie I created as a thumbnail for her video. I guess in her rush to spread hateful content against a complete stranger, Ducky failed to realize using someone else's copyrighted work for private financial gain is illegal. Well, the thing is I didn't use it for financial gain because I don't have any money from using it. I did not use it for that. So no, I did not do anything illegal. And then he cites Law Cornell. Oh, son of a bitch, I missed one. Oh, I didn't share it again. Sorry. I'll share it again. Nope, that's not what I want. All right. Okay, now we will share it again. No, it wasn't an AI version that I used then. When I saw Ducky use my copyrighted work without permission, I decided to say something to YouTube. Oh my gosh, I'm sorry, I keep having to do this because I keep missing crap. Yeah, I guess so, because it's a public one. I am mean, y'all. I am so mean, apparently. Oh my gosh, I missed some, and I thought I had already. Okay. All right, now we'll share it again. I'm so sorry, guys. I did not have time to do this before. Okay. So we had 1, 2, 3, 4, 5, 6. Okay. He decided to say something to YouTube. Unlike Ducky, YouTube understands and cares about copyright law. No, they just won't want to be sued by people. For good reason, because when people like Ducky break the law and post infringing content on YouTube, YouTube itself could face liability unless they comply with the notice and takedown procedures of the DMCA. That's why YouTube takes copyright complaints seriously, because it's the freaking law. Yes. And I address that in my whining, as he so calls it. So I sent YouTube Notice to YouTube letting them know Ducky was using my work without permission. YouTube agreed and they pulled her video down. A few days later, Ducky sent me an email, or at least she tried to. She initially sent it to the wrong address. Yeah, I did send it to the wrong email address. He's admitting that, but I tried to reach out to him sooner. I just had the wrong email address. This led to an unhelped exchange of a couple emails. I sent Ducky a pretty long message. I'm guessing she already made a YouTube video about it, but maybe not, since telling both sides really isn't. Jesus fucking Christ. Yeah, making it it's just and I didn't make a YouTube video about his email back to me. I didn't. And I'll show you why later. Because I was actually trying to be a decent human being, which is something he knows nothing about. So, yeah, YouTube took my video down. Fine. But you know what I did? I took that copyrighted work out of it, the whole first minute of the video, and reposted it without copyrighted stuff. So, there's that. All right. Okay. So, telling both sides. But yeah, so telling both sides, you're right. I don't cover documents that Gingras files. I don't cover documents that Owens files, so that their version of the story is also out there and people can choose what side to believe. But yeah, I don't care about telling both sides. What have we not shared where both sides information isn't out there? So that's a lie, and I don't know why he keeps saying it, because it's not true. Anyway, that was all water under the bridge, or so I thought. It was. You sent me that reply. I gave you a response back. You never responded back to my reply of that message. And I didn't share that message because you asked me not to. You asked me not to share that message. And I thought, okay, I won't share it, but I'm going to. And it was all water under the bridge. And now you put this shit out. And so now I have to defend myself as to why I didn't put that out there. And it was all under the bridge until you included me in a filing in California. He says, and then last week, I received a letter from the State Bar of Arizona. The letter said the bar received a complaint from Ducky on October 15, 2025. The full text of the complaint is shown below. So he goes over what I sent. And I sent a similar one to California with just the rules and stuff changed. Basically, Ducky told the Arizona bar I filed pleadings in San Francisco containing knowingly false and baseless allegations about Ducky. He says, really? Nothing I filed in San Francisco even mentions Ducky. To be fair, on page 6 of my motion for sanctions, etc., and he has the link for it. Yeah. I don't know if he fully knows anything about the um California one. I don't know if they've sent it to him yet or what, but okay. I included a screenshot of the YouTube thumbnail from Ducky's video about me. Yeah, the one he struck is the one that he included in the video. Or the one he struck is the one that he put in a court document. I mean, he had a problem with other people, but he can use it for his own one because it's his picture. This was done simply to show the court why I was asking for sanctions against Omar. But the thing is that I don't have anything to do with Omar. And you put in there that we were involved in like a conspiracy with Omar. You also claimed in a blog that I was basically a criminal. And I think it's cool to break the law. You even repeated in this. And so, yeah. Because he lied to the court in his motion to disqualify me. And within days after the motion was filed, Omar's motion was republished online by several people, including Ducky. Again, I never mentioned her by name. And I certainly made no false and baseless allegations against her, aside from the fact that she created a 2-hour video about Omar's motion, which was completely true. She did. So, what part of the claim was untrue? That I'm in a conspiracy with Omar, and that Omar makes all his little friends post videos for him. Anyway, apparently Ducky believes, the First Amendment only applies to her, and she is the only person allowed to say mean things about other people online, because my sanctions motion simply mentioned her channel by showing a thumbnail. Thank you, Emily. Yeah, apparently showing an image is not mentioning me in a court filing. Yeah. Let's see. And I joke about us, the JFC, being the justice for cult because we want justice for people that are true victims and everything else, even though we're not really in a cult. Keep having to do this. Okay. Showing a thumbnail, decided to ask by showing a thumbnail blank, decided to ask the Arizona bar to punish me. Makes sense. Yeah, I didn't do it because you posted my thumbnail. It was the words that went with it and the implication of putting Lauren, myself, and Echoes in there because you publishing those 3 people and complaining about Omar and needing to be sanctioned is you putting us all 3 together and saying shit that we are doing something that we are not. The bar's response was to swiftly dismiss Ducky's complaint 48 hours later. The dismissal letter is here, and I read that to you. Oh, he wants to say ducky dismissal here. Couple of interesting things about this. We'll get to that. Okay. So far we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 22. 22 times that he has mentioned my name. First, the letter was not from the bar guy. Okay. I've been dealing with that guy's name is Jim Lee. Instead, this letter is from a different guy who works for the Arizona bar named Matt McGregor. And I showed you on my dismissal that Matt McGregor is the one who did it. I have also spoken to Matt McGregor today. He called at the same time I found out about this. And they were like, "Hey, did you get my message?" And I said, "I did." "Oh, yeah, your Bruce's picture was in there too." So Bruce, Lauren, me, and Echoes, and Omar, he claimed that we were all doing things together. That was the implication and what was stated. That Omar has his friends do things, like do his dirty work and things for him on behalf of Omar. And nobody is doing anything on behalf of Omar. Nobody's doing anything at the direction of Omar. And nobody is doing anything at the direction of Lauren or any of us. But when I talked to the Arizona State Bar today, because they called me just to make sure that I'd gotten their email and everything like that, I said, he asked, how I was doing. I said, not great, because this attorney just doxed me on his Arizona's law page. And so he said I could possibly file a complaint with them. Don't know what would happen with it. And I could also add it to my amend my complaint against him in California. Bruce, you should have gone salsa dancing. Man, Omar, I bet got some flavor. It's just insane. So Arizona wants me to add it to my complaint in California. But I can also try to file it there in Arizona, just because it's all stemming from California. Arizona might not be able to do anything about it. But Arizona State Bar at least knows that he doxed me. Whether they took note of it, I don't know. But the guy knows about it. As far as I can tell, he's a good, sensible guy. That leads to the second interesting thing. Matt dismissed Ducky's complaint primarily because, I'll paraphrase, why are you complaining to Arizona Bar about things that happen in California court when the person you're mad at is licensed to practice in California? Go talk to the California Bar, not us. Yeah, except for that's not exactly how that went. And I showed you. They were helpful. They weren't like, "Why are you complaining to us?" No, they were like, "Hey, this needs to be done in California. Here is the resources so that you can do that." Matt's letter does correctly note lawyers in Arizona can, in theory, be subject to punishment even for conduct occurring outside of Arizona. So, for instance, if an Arizona lawyer went to Florida, oh, it's a nice example here. Because you are in trouble in or Florida as well, I believe, and murdered someone. He didn't murder anybody that I know of. Clearly, the Arizona bar could take action against their license. Duh. Okay. So if something happens in California, I can report that back to Arizona and he can be disciplined there possibly. So it's not foregone that Arizona is not going to deal with any of this. But I don't agree that Arizona has any authority to act as the initial investigating agency with respect to conduct that occurs in California, particularly in a California court. For one thing, the Arizona rules of professional conduct do not apply in California courts. California has its own ethical rules for lawyers. Where does the state of Arizona get off telling California what legal standards should apply in California courts? Well, that's funny because when you signed your declarations in the California courts, you signed them under the penalty of perjury in Arizona and not California. So some things you think Arizona can be and and other things you don't think Arizona should have any authority, but you sign under the penalty of Arizona when you're filing in a California case. Make it make sense. Um, Arizona does not have the authority, nor does any other state. That's just the way our federal system works. No state can legislate except with reference to its own jurisdiction. Each state is independent of all others in this particular. And he cites a case. In short, California law controls what happens in California, and Arizona law controls what happens here. But the Arizona bar cannot apply the Arizona rules to conduct occurring in California. Doing so would violate California's right as a sovereign state to make its own rules. But the thing is your behavior is happening in California or is happening in Arizona because that's where you're doing all of your filings from. It's just they are in California. Oh, wait, this leads to the third interesting thing. The Queen of Darkness herself, Lauren, recently filed a complaint with the Arizona bar that is basically identical to Ducky's. No, actually, mine is basically identical to Lauren's because I use Lauren's as a template. I put my own things on it. Like it's not completely hers, but I didn't know how to write this stuff up. So I did mine. I put my information in there. And so, yeah, they're basically similar because it was the same stuff. Lauren had it worse than me in the court filings than anybody. She had more stuff to complain about than I did because it was just the conspiracy mention as far as the filings went. So, like Ducky, Lauren whined about the fact that only she is allowed to talk trash about other people. No. And like Ducky, Lauren claims some of the things I said in my San Francisco pleading hurt their widow feelings because they were all just big fat lies. They don't hurt our feelings because they're big fat lies. We just don't like people lying on our name. Marissa, proud to be a part of the No Mugshots lot. Yes, congratulations. So, are we like a cult now? Is Little Ducky our leader, or do we have to vote on it? Well, Gingras made the made Lauren that. So I mean, I guess. But apparently, even though Lauren is the cult leader, she's still apparently taking direction from Omar, according to Gingras. So is Omar the cult leader, or is Dave the cult leader, or is Lauren the cult leader? I mean, there are no leaders because this isn't a cult. Um, so it wasn't about hurt feelings. It was about the false statements and the lies. Not about us hurting you. You can say things all you want. You can say you don't like us, but you cannot state lies. But guess what? Guess what? Unlike Ducky's complaint, which the Arizona bar tossed without even asking me to respond, that they did. Lauren's complaint went to our old friend Jim Lee. You can see where this is going. Unlike Matt McGregor, Jim Lee forwarded Lauren's complaint and demanded that I respond to it because, of course, he did. Okay, here's my response. Note, as you can see from the date on the letter, I sent this to Jim before I saw Ducky's complaint, which was dismissed by the Arizona bar and sent to me on October 17th. Yes, Lauren filed hers before me. And I can see why they would take Lauren's more seriously than mine. For the fact that you said a lot of horrible things about her. Like, you stated that in black and white, knowing that they weren't true. Because you know all of this is not true. So I guess rather than applying the law neutrally, the Arizona bar applies different standards based on which bar counsel you're dealing with. Well, it's kind of like when you appeal to like a single justice in the Supreme Court. Each justice is going to have a different view on things. Some may agree and some may not. Um, so yeah, it can depend on it. And then eventually it will either be dismissed like mine was, or it won't. But it's okay for them to do that. And I'm glad they're at least investigating it there. And this is why they know. And if my complaint, even though it was dismissed, helps Lauren's, great. The State Bar of Arizona needs to do better. Well, so do you, sir. So do you. It is a governmental entity, and they are legally required to treat everyone the same under the law, but they don't. So, am I supposed to be mad that they're doing better for Lauren than they are me? No. Like, I'm not mad about it. You are. But remember, you don't care about your law license anymore. You want to go away from the bar on your own terms. So why are you all mad about it? I mean, this isn't going to be on your own terms, but like you eventually wanted out of the Arizona bars recently, you said. As I mentioned in my intentional brief response, Arizona recently expanded its anti-slap laws. Why does this matter? It matters because, in addition to protecting free speech, the law also covers the right of petition. This means filing a request with the government entity seeking relief. The pleadings I filed in San Francisco represent my exercise of the right to petition. Omar lied to the court, but you have no proof that he lied. You keep saying he lied, but you don't have any proof that he lied. So I petitioned a San Francisco judge for some relief. I didn't get it for technical reasons, but that's not how the right of petition works. It's a constitutional right, regardless of whether you win or lose. You can write a petition. You are not allowed to lie in that petition. You want to say that Omar lied, but you lied. And you brought stuff that is YouTube related into a case that has nothing to do with it. So that means if Jim Lee wants to pursue charges against me, he will have to overcome the Arizona anti-slap law. Okay. This means he would have to show that I actually did something illegal in California. Lauren's primary complaint was that I lied to the court. But of course, I did not lie. Every word I said about Lauren was true or an expression of my opinion, but you didn't state it as your opinion. You stated them as fact. And the courts are not for opinions unless it's a judicial opinion and it says opinion on it. The court of law is for facts and evidence. It is not about speculation, and it is not about opinions. You can write your opinions on your fucking blog as long as you're honest. You can say it's my opinion, this, but you cannot state things as they are a fact when they're not. So, yeah, I think you did something illegal because you stated them as a fact. You didn't say, in my opinion, Lauren is doing this, Omar is doing that. You said they are doing this. I mean, granted, the filing read more like one of your crazy blog posts, um, it, but it wasn't. It was a court filing. Anyway, if the bar ever moves forward on the other stuff, I might share more details about what's going on. Personally, I'm looking forward to having my day in court, confronting my accusers, and having a chance to test their claims. Okay, let's do it. And so here is the email that I guess that he got. Mr. Gingras, State Bar recently received a bar charge against you from me, basically. I don't want the highlighter. Ah, that was too much. I am just not doing good with this. It's because it's late. Dang it. Okay. After our review of the charge, we've determined that no further investigation is warranted. We therefore consider this file closed. The closing letter, Ducky, contained the following, and then he said what it is. Then here's where he decided to dox me. So, and I said, does this individual represent you? No. How did you come into contact with this individual? Through covering a case about a client David Gingras represents, as well as putting me into a court filing. No lies there. Is your charge of misconduct about conduct in a lawsuit? Yes, because he put me in a court filing. And just so you know, I guess I should announce that we now have a P.O. box, that if y'all want to send things, letters or drawings or anything like that, I now have a P.O. box for Loud Little Ducky. So there's that announcement that Gingras helped me make. Okay. What is the general nature of your charge of misconduct? And I put, so this is where my bar complaint is. On September 15th, 2025, California Attorney David Gingras submitted a filing in the Superior Court of California, San Francisco, containing knowingly false and baseless allegations about me, a non-party with no involvement in the litigation. In this filing, Gingras used my online commentary to make irrelevant and defamatory claims accusing opposing counsel, myself, and others of a deviant conspiracy. During which, that's the exact words that he used. During this time, Mr. Gingras is not counsel for any party, just a mere intervener for retaliation. His actions serve no legitimate legal purpose and are not based in any fact or law. So far, I don't think I'm lying. Mr. Gingras's intentions were to harass and misrepresent me due to him having a personal grievance coming from my protected speech and reporting online. He made these statements in a filing under the penalty of perjury of Arizona due to his residency and law practice being there. On September 15th, 2025, Mr. Gingras submitted a court filing to intervene in a case in which I am not a party or a witness. In the filing, he falsely accused me of conspiring with opposing counsel, a licensed attorney, for my coverage of a highly publicized case. I have never even spoken to or met opposing counsel he accuses me of conspiring with. Falsely accused me of harassment, lies, and attacking someone. I have done none of those things. These allegations were unfounded, irrelevant to the legal issues, and clearly intended to defame, harm my reputation and credibility, and I am not involved in the case in which Mr. Gingras has tried to parachute me into. My only connection to this ongoing litigation is as a YouTube commentator known as online as Loud Little Ducky, who follows and discusses legal filings and true crime. This includes filings in cases involving Mr. Gingras's clients. Let me know if I have lied here. Because if I have lied, I would like y'all to call me out on it. Because I want to be able to correct the record if I did so. He previously filed a copyright strike with YouTube against me, where he alleges it is about me reporting on him using a picture where, when admitted later via email, it is actually about a public court filing he disagrees with, not a fair use picture for reporting. Yeah, he states that in his email to me. Remember, that's the email that I did not share because he asked me not to in trying to be a decent human being. But, I am unkind and mean. On September 13th, 2025, Mr. Gingras wrote on his law firm website blog that I was a cult member and implying that I am a criminal. I am not a criminal or a cult member. He has made statements threatening to sue legal commentators for discussing his and other public court filings, attempting to use his license to silence and financial consequences. These actions reflect a pattern of using his law license to retaliate against people he disagrees with rather than represent his clients ethically. Mr. Gingras's conduct violates a plethora of provisions for the Arizona Rules of Professional Conduct. Rule 42 ARS Supreme Court rules as listed below. ER 4.1, truthful in statements to others. His court filings contain false statements of fact communicated to third parties through public records. ER 4.4, respect for the rights of third persons, including knowingly false and irrelevant allegations about myself, a non-party. He has used the legal process to harass and burden a third person. ER 8.4C and D, misconduct. He has repeatedly engaged in conduct that involves in dishonesty, fraud, deceit, reckless or intentional misrepresentations to the court. These facts are prejudice to the administration of justice and undermine confidence in the legal system. ER 3.3, candor towards the tribunal. He has knowingly made false statements in court filings presenting fabricated allegations as fact to the tribunal. Mr. Gingras's filings place false and harmful allegations in the public record associating me with unethical conduct. These actions cause reputational harm, emotional distress, and create a chilling effect on protected speech. His misuse of legal filings to target non-party undermines the integrity of the judicial process. Mr. Gingras is already dealing with a second DUI in Arizona as of July 6, 2025, with the Phoenix, Arizona Police Department. To my knowledge, he is awaiting for a disciplinary hearing on recent behavior in the Owens v. Eckerd matter, a case in Maricopa County. I am not sure if those have been brought to your attention or if even need to be, as it is in another state. It okay, so, um, I'm trying to I haven't talked about the case yet. Let me finish this, and then I will kinda go over my thoughts on some things. Um, this actually is I feel like this is part California bar complaint and part Arizona, but maybe it's not. Maybe I'm getting them mixed up. Um, yeah, because it was in another state. I just think you should be aware of a lawyer's conduct that is a member of the Arizona State Bar. I can provide the following evidence upon request: a copy of the September 15th, 2025 filing with false statements. And actually, I think it was actually an October 1st filing, and I got the date wrong. Email sent to me by Mr. Gingras admissions of ulterior motives of the copyright strike, relevant court records, and public commentary that provide additional context, screenshots and or links to videos and blog posted on law firm website. Mr. Gingras's actions represent a serious misuse of the law license for the purpose of bullying, retaliation, and public misrepresentations. His behavior violates at least Rule 3.3, 4.1, 4.4, and 8.4, if not more, in the Arizona Rules of Professional Conduct. This reflects conduct that is unbecoming of an officer of the court, as well as prejudicial to the administration of justice. I respectfully request that the State Bar of Arizona investigate this matter and take appropriate disciplinary action. I am willing to and able to provide further evidence to support the complaint. And most of what he most of my writing, except for the parts that were done, like I said, I did this with the help of Lauren Knighty, as far as her template goes. Um, okay, let's present this again. And see, here's where I signed another thing. So I understand that most written charges eventually become a public record. This charge form and other submissions by me will become part of the proceeding. I understand that all information on this form, including my name and address, will be available for review by lawyer, legal professional, alternate business structures, parties to the proceeding, and others who may view the file. Yeah, that doesn't mean that you just get to put my information out there, but this is why I don't know that I can do anything about it, is because it could be part of the public record, and so I may not actually be able to do anything about it. And then it was signed. David Gingras is a solo internet and First Amendment attorney based in Phoenix, Arizona. All right. So, got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 34 times. 33 times he mentions my name. 34 if you count my phone number. Okay. Yeah. And I don't care if he states things as his opinion, but he doesn't state them as an opinion. He states them as fact, which is just not okay. It's just not. Um Omar's deep state. I didn't see that coming. So, like Lauren is president, Little Ducky is VP, Bruce is CIA director, Megan is FBI director. Yes. And Tug is like the press secretary, and Breadsticks is our Federal Reserve. Yes. The Breadsticks is our treasury. Yes. Um, and Dave Neal is our PR department lead. Wel- welcome, Susan, in becoming a new member. Welcome to the pond. All right. Okay. So there is that. I will make a separate video on David Gingras's email he sent to me. Oh, I like that, Israel. Israel says he will nominate himself for compliance coordinator. Yes. Yes, Gingras. Boatless is racking up bar complaints, and his only strategy is to try anti-slap against the bar. What a dumbass. Yeah, like it's to threaten um, financial problems and consequences for people. Okay. So now let's go to why is it okay. I guess I'm gonna have to go to Twitter to get the documents because I don't see them on Volo. But maybe Volo, victims of Laura Owens, hasn't had a chance to put the filings up. Well, it says that she did. Okay, there's that link. I wonder why it's not showing up on the actual page. Okay. That's weird. All right. So I have thoughts. One is that Laura Owens is not going to be in California because one, she doesn't have permission. And I don't as dumb as she is sometimes, I don't think she's dumb enough to leave the state without permission from the criminal court. And so I do not think she will be there in California. I don't know if she will show up on Zoom. And personally, I don't think that it is damaging to her health to be on Zoom if that's what she chooses to do and not come to California, but stays in Arizona. She could also be held in contempt because she's not listening. listening to what the judge says, but because the judge's order states that it is how did they put it? Let's actually look at this first. Okay. There shouldn't be any audio with that. Okay. So this is the minutes from the hearing last Friday on October 10th. That was the motion to intervene and motion to disqualify Gingras that they did. And Carolyn Gold was the judge. Says all remote appearances are conducted through Zoom, a video platform in accordance with San Francisco local rules of court. Tentative ruling update, no calls and or objections from either party. Hearing appearances, petitioner is present by video in pro per. Respondent is not present. Counsel for respondent, Omar Serrato, is present by video. So Omar and Owens both zoomed in. Findings and orders. Having read and considered the pleadings, declarations, and other evidence submitted in this matter, the court makes the following findings and orders. A tentative ruling is adopted. The court hears oral arguments from counsel Serrato and petitioner regarding the upcoming trial set for October 21st and 22nd, 2025. Additional orders by the court. Both parties are to exchange and file their list of witnesses and exhibit list 10 days before the hearing. The court permits out-of-state witnesses to appear via Zoom. The court notes that looking at the basis for the reissuance of the original DVRO, the petitioner needs to show to the court by a preponderance of evidence what happened during the renewal time, and since then, that makes petitioner feel that she needs the reissuance of a DVRO. The court will hear live testimony from both parties, including witnesses during the trial. With regard to the CCP 473 filed by respondent, petitioner indicated that she was not properly served, and the court confirmed that there is no service filed on the docket court. Counsel Serrato indicated that the respondent is withdrawing the CCP 473 motion. The court strongly suggests that all parties appear in person and third-party witnesses may appear via Zoom. So, I don't think she will be held in contempt. I don't know. The judge might be unhappy because she said it is strongly. Oh, y'all can't even read this thing that I'm doing, but I'm reading it to you. So it says strongly suggests that all parties appear in person. So it's a suggestion. It is not an order that she has to appear in person. So I think she will show up via Zoom. I do not see why appearing on Zoom is life-threatening to her. I think that's a crock of crap. Appearing on Zoom isn't going to kill her. But yeah, it's not ordered she appears in person. So she can't be held in contempt. It is just a suggestion. The judge may be unhappy with it, but it's not ordered. All right. Petitioner indicated that she has 8 to 10 witnesses and respondent will have 8 witnesses. The court requested both parties to streamline the number of witnesses prior to the trial. Laura is not trying to streamline anything. Tentative ruling, motion to intervene denied. Intervention requires direct and immediate interest in litigation. This matter is from a witness to the litigation, and is ancillary. Motion to disqualify Gingras is without prejudice, and the motion is premature. Motion to strike sanctions moot as motion to intervene is denied. So that was the order from the court. Yeah, she cannot be sanctioned for not. Now, if she just doesn't show up, period, she can be in trouble for that. But if she shows up on Zoom instead of in person, no. But I hope there's like strict orders that she can't even look away from the camera, that her eyes have to be facing forward at all time. And I think that if there needs to be a making sure that Gingras is not in the casita or that Laura is not with Gingras. I mean, could they be on FaceTime if they're both on Zoom? But could be. I wish I could be there in person. I really wish I could have, but that is not something I can afford. Okay. So now let's see what Owens has to say. So, all right, y'all can hopefully see that. Expedited request for reconsideration of motion to continue filed on the 17th of October, which was Friday. Wish it had a timestamp on it. Owens, which is the petitioner, it was pro per in versus Maricini. She said this is based on urgent health concerns and request for ruling on papers. Well, she already said she wasn't ruling on papers. And if you're ruling on the papers, you have done nothing to prove that Mike did anything to you. And you want ruling on papers because everybody's just taken your word for it up until recently. And you know, something that I find very interesting is that in, I believe, all of the courts that she has won in, like, well, maybe Gillespie's wasn't. No, Gillespie's was. That every one that she's won in, Mike Maricini from before, and Greg Gillespie, then the order of protection in against Clayton, everybody that she's faced and she's won against are male judges. And it's funny that the two judges that seem to not be dealing with her nonsense are female judges. And I have heard that you would think some people think, oh, like women jurors and women, they're more likely to be sympathetic because, they're mothers and women as well. And that it has been said that actually women are not the ones who just are like, oh my gosh, that's so sad. They're actually quicker to point out the BS and think that something doesn't sit right and be like, see, I'm a girl, I'm a woman, and that's not something I would do. That's not something a woman would do. Something's fishy here. So I think it's interesting that it's the men, the male judges and commissioners that have been like, "Oh, you poor little girl. Yes. Like, just look how tiny you are. Like, who could you hurt?" And they're like, "Here's you a protective order. Here's like, we're just gonna believe everything you say because, believe all women. Guys don't wanna just not believe all women, right? Especially in the legal sort." And the female judges are like, "No, fuck all that. Like, this bitch is lying." Yes, we do have a serial liar. She's not good at lying, and she's very dramatic. Mm, no, the Zoom hearing is not gonna be available to the public. Nothing with this is available to the public unless you go sit in court. Um, God, I hope she cleaned her room, which I need to clean mine. Um, but hey, you know what? That's something to feel good about. If you don't live in squalor like her, like, you should be very proud of yourself for accomplishing that because it's real easy to live in squalor. So, if you're not, give yourself a pat on the back because you are doing something productive by cleaning your place of living up. So, introduction. Petitioner Laura Owens respectfully requests reconsideration of the court's prior denial of her motion to continue the domestic violence restraining order renewal hearing, DVRO, presently set for October 21st and 22nd. Well, at least she gets it right here because she was saying 20th and 21st. New objective medical evidence demonstrates that proceeding as scheduled would pose a life-threatening medical risk. How does sitting on a Zoom call for court pose a life-threatening medical risk? It doesn't. To petitioner and deny her ability to meaningful participate in the proceedings. Well, like, there's not, like, I know people that have done court from their hospital beds. So she can participate meaningfully. Like, it's not like she would be on the toilet the whole time or something. New medical evidence. Attached as Exhibit A, which we do not have that exhibit for whatever reason. Could be because it's medical records and medical records are not shared. Is a letter dated October 17th, 2025 from Dr. Colleen Green, a medical provider that petitioner has been seeing since September 2024. Okay. So she has been seeing this doctor for at least 13 months, a year and a month, over a year. Dr. Green states that participating in a hearing next week would be life threatening for her because of the combined psychiatric and physical decline. The reason she has a psychiatric decline is because she doesn't like being held accountable. She doesn't like being held accountable. And so her being called out for her lies and getting caught in more lies, possibly more perjury or criminal activity by perjuring herself or doing arts and crafts on things, that is making her psychiatric decline. That is her fault. That is her fault. And the fact is that you could have got this Exhibit A prior. You've known for a long time that this was going to happen on the 21st and 22nd. And you get it a week after you've been denied your continuance. You should have filed this Exhibit A in your first request for continuance, but you didn't. Um, it has, and it's not gonna hurt her physically either. Like, there's nothing. The new evidence unavailable when the court previously ruled, that's because she didn't get it. But anything that's happened from September 2024 to before October 17th, 2025, none of that's new. The practitioner has known about all this. Um, which directly rebuts any assumption that petitioner is capable of safely participating in a contested proceeding at this time. No, she is trying to act like she's trying to do this because she's going to say that the reason that her psychiatric decline is because she can't be in a courtroom because she's so scared of Maricini, Gillespie, and Eckerd and Woodnick. She's so scared of all those people that she just cannot be safe. But the thing is Mike Maricini has the right to confront his accuser. In addition, yeah, we don't need in addition because you did not attach any in addition to things. Also, mm, she is a psychiatric mental health psychiatric nurse practitioner out of Tucson is Colleen Green. And so the thing is that anything that this nurse practitioner has to say is based on Laura's own reports. She is self-reporting. Everything that the psychiatric nurse is relying on is based off the things that Laura has told her. So she doesn't have any concrete medical evidence unless she sent her for some blood panels for psychic stuff. Um, it's self-report. Also, is she on meds and is she taking them? Because January, when the police came in there with their search warrant, she didn't seem like she was on her meds. So her meds are not working and they needed to be adjusted. And I hope they were adjusted after that because she can be like, well, they didn't keep me calm. This is the consequences of her action. And she just thinks she likes to do things ex parte where people can't fight back against her. Well, that's just not how it works. And she's gotten away with that for far too long. Where's that comment? Marissa states, as someone who lost their baby at 28 weeks, I am so sorry about that, Marissa. I completely understand that. I lost mine at 22 and a half weeks and had to plan a funeral for her. I did too, because after 20 weeks, and I think it's in the US, they have a death certificate. So she said, I hope she sees prison time for all the fraud and lies she's perpetuated on these men and the courts. I agree. And she has no clue what any of that is like. Because, what we don't like is after losing a baby, and the hospital's like, "Have you picked a funeral home yet? Have you picked a funeral home yet? We've gotta get her out of the morgue. We've gotta get him out of the morgue, so we need a funeral home to come pick him up. So have you picked one that can come get the baby?" Laura knows nothing about any of that shit. And that's the last thing, and it's like, "No, no, I did not pick out a funeral home because I was expecting to have my baby living. I didn't have this in my birthing plan to pick out a funeral home." So, that's the kind of shit that pisses people off about Laura, is people that are actually people that have gone through this shit. Yes, self-report equates to hearsay. Yeah, I don't think she's taking any of these. But she wants to talk about other providers, but she doesn't want to provide any of that information except for what she's doing is self-reporting to us. She talks about where she got these things done, and I'm sure she should be able to provide a copy, but she just says that she attached Exhibit A. And so her psychiatric person isn't the same one dealing with gastric stuff. She can be dealing with the extreme anorexia and the so-called autism, which we don't even know where she even falls on the scale. And um, most of us probably have a little autism in most of us. Some it takes over our life completely. Some of us, it's not really considered autism because it's just little things that can be considered autistic. But we also know that Laura lies. So do we think she was honest about her evaluation or questionnaire that when she took her autism test? No, because she exaggerates and lies. But she says the other treating professionals have diagnosed her with streaming anorexia after a 50-pound weight loss. Height, height 5'5", approximate weight is 84.9 pounds. Um, are you actually anorexic? Which she could be. She's very thin, but is a part of her thinness related to doing like some kind of Ozempic or something similar to it, where she added that on top of the anorexia? And she cannot blame anybody reporting on her case for anorexia because nobody has called her fat. Nobody thought she was overweight or anything. Nobody made comments about her body. So she can't say it's because a bunch of people said this about me and my body and then it made me think about this. No, it is to me stress induced, but it's stress that she caused in her own life. I want her to get help. I would like her to get back to a um healthy weight. Yep. Yep, they will add that they offer you the smallest casket. I did pink. It is too big. Um, and while people, like, oh God, what did I do? Okay, I don't know what I just did there. Okay. Let me show this. Okay, set it from the get. No way that this malnourished body free limit. Well, the thing is that I don't know if she's infertile or not. She also wasn't this small, um, when she supposedly got pregnant any of the times. I think she was taking, like, a GLP-1 injection. That is my opinion. The only reason I say that is because when we were looking at the scale, when she was talking about her weight, because she was saying the weight loss is due to her not being pregnant anymore. So she lied about that. The weight loss was not due to her not being pregnant anymore. It was because of her eating disorder. And but that somebody had found that that exact scale actually goes with a weight loss company that gives it out. I forget the name of it. Like, it started with an L. Livio or Livii or some I don't know. It started with an L, I believe. Um, and so that's why I think part of her weight loss also has to do with GLP-1 injections. But HCG, if taken as well, is also can be a weight loss thing. It was kind of a weight loss thing before, like, Ozempic and stuff. People would use HCG. So, I think there is some kind of weight loss thing in there. Um, she might have the eating disorder as well. I don't really know. Okay. And she says her recent labs, gastrointestinal bleeding. Now, I do not think she has a lower GI bleed. I don't even know that I think she has a GI bleed at all. But if she does, to me, it's an upper GI, um, because she talks about vomiting blood. And so that would be your upper GI tract, because it's coming out the upper portion of your body, um, and it's not coming out the lower end. And I've had a lower GI bleed. I was hospitalized for it for a while. Um, and she talks about August 7th, 2025. Well, and it's approaching transfusion range. Well, I've had to have a transfusion. Guess where I was? The hospital. A- And you say, oh, it's corroborating the seriousness of her condition. Well, this is 2 months ago. What has been done in the last 2 months to deal with this? Nothing. Nothing until you decided you had to go to court. And so you needed to act on this. And this is malpractice if nobody is treating you for this and sending you to get care, or you just not um, doing anything because you would be admitted. So she talks about multiple episodes of vomiting blood. Um, when I vomited blood, which is stupid that I have to say that, when I vomited blood, I was actually at the Walmart pharmacy. And it was after I had had my tonsils and adenoids and an abscess on my pharynx removed, along with getting tubes in my ear. I was actually an adult at the time. And I was having problems with my healing. And I had just gone to the emergency room again because I had tons of pain that was still happening. Um, and it was causing a lot of issues. Well, when I left the emergency room and I went to go pick up my prescriptions from the Walmart pharmacy, I all of a sudden start having blood coming up. And it was coming out my mouth, it was coming out my nose, and they're like, "Trash can." I'm like, It's gonna be biohazardous." And but it would not stop. So Walmart pharmacy calls the emergency or calls 911, and I have to be taken out of Walmart in in a stretcher and all that. And sadly, like, my daughter was in she was in pre-K or kindergarten. I think she was in kindergarten at this point, and one of her friends was walking into Walmart at that time, and saw me just bleeding everywhere, and then going out into the ambulance, and that poor girl, she was, like, traumatized because she went to school and told my daughter, "Oh my god, I saw your mom, da 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 da," and I didn't even tell my daughter about that because I didn't want my daughter, in kindergarten to worry about that kinda stuff or hear that kinda gruesome detail. I She just knew that mommy was sick and not feeling well after her surgery and that she had to go back to the hospital. And so I didn't include all that stuff, but her friend was like, "Oh my god, is your mom okay? She was bleeding everywhere." And so when she says that she's been vomiting up blood, um, and nothing emergent is happening, it doesn't ring true to me. Advised that urgent gastrointestinal testing and specialist evaluation were medically necessary. So, how do you know you have a GI bleed if you have not had gastrointestinal testing? Because you need an endoscope or a colonoscopy, maybe both. And they are medically necessary, but you should have been handling this from the time of at least August 7th, 2025 until now. You've had 2 months to go get this stuff handled or go to the emergency room, and it kind of forces them to take action and start the action and getting things going for you. Petitioner was referred for gastroenterology consultation. Yeah, you don't you should be having a test. This consultation should have already been scheduled way back in August, which included, October 22nd was the earliest date available. She was probably like, "Well, it needs to be like, do you have anything like Tuesday and Wednesday of next week?" That's probably what she said. Oh god, what did I do now? Ah, there we go. Um, so yeah, they're enablers. Yes, I have so like sometimes you will see me post that, I'm not going to be able to post a video or I've been sick or I've been in the hospital. My health is not great. Um I had an issue when I was 13 with my ovary and my appendix. And then I was pretty much fine, like, and I never really got, like, colds or and things like that, like, didn't have, like, normal sick stuff, um, and then I had that one fluke thing that happened when I was 13, and then once I got well, and I guess I lost my daughter too, but most of my health problems came after I had my daughter, and so at about 23 is when all my health went downhill, and I'm still dealing with so much health stuff. Um, I am like, I have my doctors and like medications and stuff like that that helps, just get through regular days stuff. But so I'm able to function, but I get hospitalized a lot for different things too. So, but I try to consider myself lucky because things that could actually be worse than they are. But she talks about the overlap of the hearing dates was entirely unavoidable. No, yes, it was. It was a very avoidable. It immediately fell. Um, upon referral for a very serious condition. Postponing this appointment could delay essential diagnostics for several weeks. Why would it delay it for several weeks when you scheduled it on Friday and you were getting in 2 or 3 days later? So you're telling me it would take several weeks for you to get another appointment when it only took you like 2 to 3 days to get an appointment? You could also have gone to the emergency room. I'm wondering if you Googled or called a hotline. Significantly increase the risk of further bleeding, worsening anemia, and medical destabilization. So you have anemia or you have anorexia? Which one is it? Or is it both? And if you're anemic, get some iron in you. Iron makes me really, really sick. Um, I do not do well with iron. I've had iron transfusions as well, and it gets ugly. Says procedural urgency and request to rule on the papers. Today is the 17th, and the hearing is scheduled for 21st and 22nd. The intervening weekend, October 18th through 19th, leaves no business days to notice or calendar an ex parte application. Accordingly, there is no practical opportunity for a hearing or oral argument before scheduled dates. Well, you made sure of that, didn't you? You made sure you didn't post it a minute before you had to. Given the medical urgency and the newly submitted documentation, one note from a doctor, or not even a doctor, a nurse practitioner, which I am not going to discount nurse practitioners because they work sometimes harder than a doctor. Petitioner respectfully requests, that the court rule on the request on the papers pursuant to its authority under the California rules of the court. The provisions authorize the court to determine matters without oral argument when good cause and exceptional circumstances exist. No, they can. They don't have to. Both which are present here as proceeding next week would place petitioner at a documented life-threatening medical risk. No, it wouldn't. You could still have the hearing from your own home. Good faith basis? No, you did not make this on a good faith basis. And how much time is it gonna take her to her psychiatric decline to not be there? Because she says physical too, but she talks about her psychiatric. So, she's never gonna psychiatrically be ready for this DVRO renewal hearing. And if she would have actually asked the criminal court for time or leave to travel to San Francisco to deal with this, and then this came up, maybe it'd be more believable. But you didn't even file a motion to have permission to leave to go deal with these court matters in another state. Um, so yeah, this tells me you didn't plan on doing any of this. She wants to vacate its prior order denying it. She wants to grant a reasonable continuance of the DVR renewal hearing to allow for medical stabilization and recovery, and order any further relief the court deems just and proper. I don't know what other further relief she needs to get. Respectfully submitted. This is not respectfully submitted at all. Not at all. What have I Yes. I actually wanted, because of my health stuff, and I get tired of doctors sometimes that have never been through any health things, and they just go by, well, textbook and stuff, and they don't consider the outliers, and they they don't actually know because they've never been through it themselves, and they just are like, "Well, this is what this says. I don't know what else to say," or they're judgy. Um, I had thought about becoming a doctor, and I was like, "Well, I don't really have the time nor the money to become a doctor." And then I thought, well, maybe nurse practitioner because it's, half the time. Still didn't really have a way to do that. And then found massage therapy, um, where it didn't take much time to do the schooling, and that I get to help people not be in pain every day like I am. Um, and that I get to be a person that has been in a client's shoes and can understand where they're coming from, not judge them, and hopefully make their life better than my current life. And so, but nurse practitioners usually spend more time with the patients than the doctors do. Um, and they see a lot of clients or patients that you'll a lot of times see a nurse practitioner instead of the doctor. Um, so the nurse practitioner actually sees majority of the patients in the practice. You see that a lot. So I definitely do not discount any of that. Her declaration um for the continuance is the same thing. She doesn't really state anything new. So let's go to the motion in limine or motion in limonade. I hope the judge rules in Maricini's favor. I um I really do. I hope the judge gets pissed off for trying to pull this. Um, but we have many people that are going to be there tomorrow, and if it's continued or dismissed or whatever, we will know. Or if Laura even logs on to Zoom or anything like that. All right. Remember to hit the like button and subscribe. We are going to go into the motion in limine. I know this is a long live, but I want to get to all of these things before the court proceeding. If you have to log off and go to bed, you can do that, of course. Um, and then just start where you left off another time. Um, I may I I might try to attempt time stamping. I don't really know how to do it, but I'm gonna try to do time stamping. Alright. Did I not share it? Pineapple juice. I didn't know pineapple juice did anything like that. Hemocyte plus for anemia. And I know my daughter, when she was pregnant, she had to be on a prenatal that didn't have iron in it because the iron in the prenatal is what made her sick. And so that is what made like her morning sickness and things worse. And then when she came off the iron, her morning sickness went away in her pregnancy. But just like everyday anemia. Yeah. Um so that's cool. I'm interested to hear about the pineapple juice though. Ah. She might be doing it to make people regret going to the trial. What is happening here? Um, what in the world? For some reason, let me see something here. For some reason, it's not letting me. Let me see something here. Okay. Okay. Sorry. I didn't mean to do that. Okay. Yes. All the best. All right. So we're right about the 2-hour mark and we're starting the motion in Limine. So you would need to go to 2 hours when starting this video if you want to hear my thoughts on this motion. All right. Hopefully this doesn't do. Oh, okay. You know what? We'll just leave that alone. All right. So we're going to present this, share screen, go to motion in limine. All right. All right. So motion in limine filed on October 16th, 2025. So notice she could file this October 16th. Um, no, I'm not saying that you're pregnant. I'm just saying like a lot of people become anemic during pregnancy. And so that's part of wanting them to take iron and stuff like that. Um, yeah, emergency hysterectomies suck. They do, but that's good. And I'm not allowed to take estrogen since my hysterectomy, um, because of blood clots in the lung, pulmonary embolisms that I've had. Um, I had one a year ago, was my second one, and I had one several years ago before. Um, but so she wants to exclude a bunch of witnesses. Oddly, she actually wants to excuse one of her witnesses as well, which tells me that the reason you put this person on your witness list was not because you wanted to use them as a witness. It was because you wanted to slander and libel that person for speaking out against you in retaliation. Because why would you exclude a person on your witness list? But the first one that she wants to exclude is Woodnick, which is David Gingras, or not David Gingras's, which was Gregory Gillespie and Mike Maricini's, not Mike Maricini. Oh my gosh. Greg Woodnick represented Gregory Gillespie and Clayton Eckerd. Woodnick has spoken to Maricini before. I believe Woodnick has also spoken to Randy Sue Pollock, and Woodnick was there the day that Mike Maricini was at court because it was for Clayton Eckerd and the Owens hearing. And he is the one that subpoenaed Maricini. Woodnick also was in chambers with the judge and Gingras when Gingras and them were talking about witnesses not being in the courtroom and that they could protect with security Owens. Um, Winnick, I believe, is a witness to Gingras doing all the nonsense he was doing when he was calling the police on Mike and running around on his cell phone. So I think Woodnick was a witness to this, which is part of Owen's DVRO, um, request for renewal is because of stuff that happened at that hearing. Well, Woodnick was there to witness this stuff, so he would be a witness to that. Now, Owens thinks that he is there to talk about her character, which I don't know if he is there to talk about his character. I believe was listed as a rebuttal witness because he is going to rebut anything that David Gingras says if Gingras tries to say things that are untrue, um, or add context to it. So, alright. But she says that the identification and stated purpose of testimony is Woodnick is thus offered as not as a recipient witness, but as an expert to give his personal opinions about petitioner's credibility and mental state, topics that are inadmissible under California evidence law. Um, okay. That he lacks personal knowledge and relevance. Mr. Woodnick has no personal knowledge of petitioner's relationship with respondent Maricini. Well, he's not there to testify about things that happened when y'all were in a relationship. He's here to testify about things that happened there at the court. So, he does have personal knowledge of the nonsense that you're accusing Maricini of traveling across state lines to harass and intimidate you, which is not what he did. So, that's a lie. He No, he doesn't have anything to do with your relationship from back way back then. But see, this DVR renewal has to do with things that have happened in 2020 to 2025, and Mudnick is very familiar with you and your antics in those 5 years. His only involvement with petitioner arose when he represented other clients in Arizona. Those unrelated proceedings have no bearing on whether petitioner continued to harbor a reasonable apprehension of future abuse from respondent, as required by Family Code 6345A. Testimony lacking firsthand knowledge is inadmissible, Evidence Code 702, and irrelevant 350. Now, I haven't checked all of these codes and citations, but some have thought that she did this through ChatGPT. I don't know if she did, but if she did, she needs to be careful because ChatGPT has put in false cases, like made up cases and like statutes and stuff, because there was an attorney that just recently, I think within the last year or 2, that got in a ton of trouble for having ChatGPT write their motions, and when they looked those cases up, they are not actual cases. So, the attorney that used ChatGPT thought that it would actually cite real cases, didn't double check it, and, um, yeah, he got in a shit ton of trouble with that. Um, so I haven't verified if any of these codes actually are real, if they say what she says they do, or anything like that. Somebody can do that if they so choose, but I figured I would point that out because that would be a problem if she's just taking ChatGPT's word for it, um, or if Gingras has helped her with those, because I don't think she's read all the rules of evidence in the family code for Arizona and for California. I'd be shocked if she had. Okay, sorry, I was thirsty. Okay, she thinks that it is bias, hostility, and retaliatory motive. Record establishes an extraordinary conflict of interest. According to the court-generated email chain dated August 1st, 2022, Exhibit 4, petitioner reported to Maricopa County Superior Court that she had been assaulted. Yeah, but you hadn't been. Yeah, you lied. So you're admitting here that you said this stuff, and now you're telling a California court that you did this, knowing that it was false, that you hadn't been assaulted. Had strong reason to believe that both the defendant and his counsel were involved, and there was a pending FBI investigation. We don't know if there was an actual pending FBI investigation. She says she called the FBI. We know she has no problem contacting the FBI, which she should stop doing, and the FBI should really start getting pissed at her for wasting their resources. But she didn't just accuse Woodnick of assault. She accused Woodnick of trying to, like, assaulting her, but kidnapping her and raping her. That's what she accused Woodnick and Gillespie to be conspiring against her to do these things or had done these things. So, no, it wasn't that she had been assaulted. Woodnick did not lay hands on her, and in my opinion, neither did Greg. The court's judicial assistant forwarded that message to Mr. Woodnick. Yeah, you know what you didn't say? Is that you wrote the email to the court. The FBI didn't reach out to the court. You reached out to the court and said these things. And the message to Mr. Woodnick and reminded petitioner that ex parte communication was not permitted. Yeah, because you wrote this to a judge. From that moment, Mr. Woodnick became aware that petitioner had personally accused him of serious misconduct. Yes, accused him. You accused him of something that wasn't true. And so, but there's no findings. There's not a police report. There's no evidence of this. It is simply you retaliating yourself. But you like to project because of you think that because you do things that everybody else seems to do it. Since that disclosure, his actions toward petitioner have reflected sustained hostility. He has described petitioner publicly as someone who fabricates abuse allegations and suffers from unreasonable fear. And that's called he was defending his client, and he also could have been speaking on behalf of his client at that time, not as himself. Um, and that's not hostility. Um, that is just opinions that he's giving. He has not treated you with any hostility. On March 7th, 2024, while representing a different adverse party, he issued a Woodnick Law PLLC press release repeating those phrases and asserting that petitioner had falsified evidence. statements made months before an evidentiary hearing or ruling in the Arizona matter. Well, you had because you admitted to it in your deposition. You admitted to falsifying evidence. So you admitted to it. So there didn't need to be a ruling from a court when you admitted to falsifying things. You said it. Petitioner later filed a state bar complaint documenting the press activity and other unprofessional conduct. Although the bar closed the file without formal discipline, the existence of that complaint this demonstrate that Mr. Woodnick's professional conduct was formally charged or formally challenged by this petitioner. Okay, I formally challenged Gingras then and his professional conduct, and the bar closed that file without formal discipline. But the existence of that complaint doesn't demonstrate anything except for you put your opinion out there. And to me, you had no evidence supporting that Mr. Woodnick had done anything to you that was unprofessional. Because if he had done the things that you said he did or accused him of, he would have been disbarred and arrested. Having been personally accused of abuse and professionally reported for misconduct, Mr. Woodnick now seeks to testify as an expert that petitioner fabricates abuse allegations. That sequence creates a textbook retaliatory motive under Evidence Code 780F, a desire to vindicate himself by discrediting the complainant. No, he's there to speak about probably things that were witnessed, and his knowledge of things that happened in Arizona. And he also knows the laws in Arizona. Let's see, bias and hostility go directly to credibility. Well, your credibility is at stake here because the judge has to find you credible in order to believe that you are in fear for your life and need a permanent restraining order against Maricini. She has to find your allegations credible. She says such bias renders him incapable of neutrality. Under Family Code 217B, the court may exclude testimony that would cause harassment or intimidation of a protected party. And under Evidence Code 352, it may exclude evidence whose probative value is outweighed by the danger of undue prejudice. Mr. Woodnick's participation meets both standards. Well, the thing is we don't have to worry about probative over prejudice because this is not a jury trial. And the judge is the one who can determine what is probative and what is unduly prejudiced. And she's not worried about confusing a jury who doesn't know how to put prejudicial and things like that to the side when the judge does. Improper expert and character testimony. Woodnick's proposed opinions that petitioner fabricates abuse allegations or acts from unreasonable fear concern credibility and emotional state, not any field of technically expertise. Well, you don't even know what you don't even, oh, God, you irritate me. Let me see something here. Greg Woodnick is a rebuttal witness, according to Omar and Mike Maricini, okay? The purpose is the expert opinion on petitioner's pattern of fabricating abuse allegations, misuse of court processes, and unreasonable fear under Family Code 6345, corroboration of findings in Arizona paternity litigation. So this means that Woodnick doesn't is not even going to be presented in Maricini's case in chief. He's meant as a rebuttal to rebut anything that is said, um, if it is not true. If they need him, they can use him on rebuttal. They may not use him on rebuttal, but he is there. And since he represented 2 other people that you have accused, yeah, he actually can respond to patterns of things that you've done in other cases. Um, s Woodnick proposed opinions that petitioner fabricates abuse allegations or acts from unreasonable fear. Okay, technically constitute unpermissible. Admitting these opinions would usurp the court's role as a fact finder. No, it wouldn't. The expert may not comment on a veracity of another witness. Well, he's not commenting on the veracity of another witness. He's commenting from personal knowledge and experience with you. Mischaracterization. Respondent's disclosure asserts that Mr. Woodnick will corroborate findings in Arizona paternity litigation. This representation is incorrect. The Arizona case contains no judicial findings that petitioner fabricated abuse allegations or lacked reasonable fear. I She says abuse allegations here, and I actually think that's a lie because she tried to say that Eckerd had raped her. Her attorney still spouts off crap about that, knowing that it's a lie. And to me, that would be abuse allegations. And so Mata not finding her credible and that she's lied about things, to me, she has issued a finding that she doesn't believe what Owen says. She does not find it believable that Owens was pregnant. And if she doesn't find it believable that Owens was ever pregnant with twins, she does not believe that Eckerd abused her in any type of manner or raping her. That's my opinion, though. Y'all let me know what y'all think. Mm, okay. She thinks that it would be an unfair prejudice and cause confusion. It doesn't cause confusion, um, because she is the judge, and it's not unfairly prejudicial. Um, Procedural impropriety. Okay, the thing is, okay, maybe the subpoena wasn't issued correctly, um, but she says that, um yeah, because she's an outside thing, which I believe she is actually correct about that. You can't subpoena out-of-state witnesses. They would just have to come, they would have to come on their own volition, or you'd have to pay their fees. But, um, she says the subpoena for trial testimony must be issued either by a court clerk or by an attorney as an officer of the court. Well, Omar being an attorney is an officer of the court, so he would be okay to sign it. Um, but it I think it does have to be in California. I don't know if Woodnick has actually been subpoenaed, or Woodnick is like, "Hell yeah, I'll come out and testify about this because she is bullshit." Um, and you do not have to have a subpoena to testify, because I doubt Gingras has a subpoena. Actually, Omar may have submitted a subpoena for Gingras, but, we know that Owens, I don't think has signed any subpoenas in my from what I know. She wants to exclude John Berryhill. Respondent seeks to call privately retained digital forensics, Mr. Berryhill, to introduce a 2024 report to text messages from 2016 to 2017, materials never filed in this case. Well, the text messages were filed in the DVRO case that you had against Mike. When you originally filed it, you put texts in there saying that he did a bunch of stuff to you. So, yeah, they were filed in this case, um, and unrelated to the record supporting either the 2018 or the 2020 renewal. See, no, I think the text messages and your credibility actually, are related to the case. No forensics examination of petitioner's filings has ever been ordered by this court. It doesn't matter if they're ordered by the court. Um, you can think they're irrelevant all you want. The thing is the text could they the judge could say that the texts are not important, but the court could also find, because this is a report that happened in 2024, that that is this newfound evidence was found within the 2020 to 2025 time period, that we found out, or he has new evidence stating that these things are what they are. Um, she talks about that they were never a part of the record. Um, she talks about retries matters. Um, and it doesn't have to be the fact that you're allowed to enter new exhibits because this is a new hearing. You're trying to renew the DVRO. So new evidence can come into play. It's not based off just your old evidence. No such documents existed in 2018, 2020 record. It doesn't matter. Um, the court files uh, renewal contain no medical letters, no ultrasounds, and no comparable exhibits, let alone anything falsified or misleading. Yeah, that is untrue because everything in your DVRO applications everything is false in there for the most part. Anything that you say that happened, it didn't happen. So you have falsified things and misled the court. Neither party nor the court has ever referenced or relied on such materials where they are now. Um, and they go to credibility. Testimony predicated on documents that never existed in this record is speculative. No, they're not speculative because they've been forensically analyzed. No court authorization. There doesn't have to be a court authorization of this. Absence of methodology. No, there's no absence of methodology because Omar, when he submitted Barry Hill's expert disclosure notice, he talked about Barry Hill was going to talk about the methodology because it's very important for an expert to talk about the methodology and validity of how this is actually true, and it is a accepted methodology in forensic analysis. Irrelevant and temporal remoteness, have no bearing on petitioner's present apprehension of future abuse. No, see, it does, because Barry Hill's report is also another part of you renewing your DVRO, because not only are you saying that Mike crossed state lines to further intimidate you, you also say that John Berryhill's report is the 2,500 pages of text messages. So, John Berryhill's things actually are relevant because you brought the 2,500 pages of things that came from this forensic analysis into one of the reasons that you are renewing your DVRO. So I think Berryhill is very relevant, but she doesn't like people using evidence against her. Like, she wants to be able to do this without anybody contradicting her because she can end up with criminal charges anytime somebody goes against her. Prejudice and confusion, nobody is going to be there's not gonna be any confusion, and to me, it's not unfair prejudice. Just because you don't like the evidence against you, it doesn't mean that it gets thrown out because it is relevant. Um, that's like saying, um, a witness to a murder, they can't come in and talk about them seeing me seeing me murder somebody because that's unfairly prejudicial. Well, yeah, but when you do crimes, usually things become prejudicial, but it has to be unfairly prejudicial. Like, it's just I and the thing is it's like saying just because she did just like we can say, just because she did something in the Eckerd case and lied in the Eckerd case, it doesn't mean she lied in the Maricini case. But we have evidence that says she did lie in the Maricini case. We have evidence she did lie and falsify things in the Gillespie case. They're relevant. Um, Gregory Gillespie, she does not want him to testify. No court has ever found the petitioner falsified a pregnancy, submitted a forged ultrasound, or misused protection orders. Such testimony would be irrelevant, misleading, and unduly prejudicial. No, it wouldn't be, because while a see, you should have said, not no court has ever. You should have said, in the Gillespie case, no court found this, but no court ever found. Yeah, people have said that you have. You have even stated that you forged ultrasounds, and you have misused protection orders. Mata would have done something for your misuse of protection orders if she could have. She just didn't have the jurisdiction to do so. Irrelevance to the renewal under family code. It's not a retrial of the original abuse allegations. Yeah, but you wanna bring in a lot you wanna bring in Callie and Napkin Lady, so, like, what are you doing? Um, Allegations concerning a separate Arizona civil case have no bearing on whether petitioner continues to fear respondent. Such testimony is irrelevant and inadmissible. He's never made threats to you or done anything to you. Arizona record affirmatively shows the absence of any finding that petitioner falsified a pregnancy, forged documents, or abused the protective order process. Not yet, at least in the Gillespie matter. Um, oh, they have supporting evidence that you fabricated things in the Gillespie case. We didn't have it then, but we have it now. Fiverr. Um, Motion for partial summary judgment established that Gillespie did not suffer any consequent proximate injury and did not incur damages and did not suffer severe emotional distress. Just because he didn't incur financial damages or suffer severe emotional distress, as you claim, they claim there, there's also a male judge, um, doesn't mean that you didn't do shit to him. Granted, both parties cross motions for summary judgment with respect to the fraud are insufficient for both claims, except for we have proof. Those rulings disposed of Gillespie's fraud and emotional distress. Yeah, but we didn't have as much proof back then as we do now. No Arizona court has ever entered a finding of perjury, forgery, or false pregnancy. You once again should have said in the Gillespie matter because Arizona has definitely found that you have perjured yourself, forged things, and falsified pregnancy. You actually have 7 indictments regarding those exact 3 things. So you lied here, committing more perjury. I just need to put my drink over here. Protective orders in the case. None have been vacated or denied. Yeah, because you had male judges that don't wanna tell a woman no. Misrepresentations and potentially to mislead the court. Mm, would misrepresent the Arizona proceeding and mislead this court into believing such findings exist. Yeah, but they have evidence that it exists. Just because a court didn't find it back then doesn't mean that we don't have evidence of it now. Lack of personal knowledge. Well, Gillespie was there, and I wonder if you told Gillespie about your past boyfriend and what a horrible person they were. He says it's biased and retaliatory. Ah, yeah, they're allowed to discredit you because your credibility, once again, is at stake here. She says it's going to be confusing. The judge is not going to be confused. Terry Bowe, a Maricopa County investigator, seeks to testify about ongoing criminal case in which petitioner has been indicted but not convicted. The subpoena served on Mr. Bowe is procedurally void, and she's going to say it's because he's an out-of-state witness. Unsigned and invalid subpoena. Out of state. Defective notice to serve. Well, if Mr. Bowe wants to come be a part of of this trial without a subpoena, he can. And if you thought that Maricopa County wasn't gonna have somebody come attend your hearing and see what other nonsense you do in California, because anything you can and will say can and will be used against you, because they could find out about new things. They could also decide to go talk to California about things if they wanted to. So just because you're doing things in California doesn't mean it can't come back to bite you in the ass in Arizona. Um, it's an indictment stage. It's merely an accusation. Well, it's not actually. I mean, technically it is, but um, there's evidence supporting it. California courts bar testimony or exhibits referencing unadjudicated criminal charges because they risk confusing issues and undermining fairness. I mean, all he has to come in and say is that, yes, she's being charged with this. That yeah, that he can come in and state that because they can't really bring that in any other way. I don't think. Improper opinion on credibility, I don't think he's giving his findings on credibility. I could be wrong about that. Let me see. Yeah, it's to testify regarding the criminal investigation, and the grand jury indictment charges with fraudulent schemes, showing a deliberate pattern of deception relevant to credibility. I don't know if he's actually going to talk about that, but, I mean, they can say, "You're not gonna talk about that." Um, okay. If they have personal knowledge, they can. Such testimony invades the fact finder's role and is barred, prohibiting character evidence to prove conduct. You're not allowed to introduce character evidence about yourself, like self-serving, character evidence. Let's see. She says that it's extreme prejudice. No, it's not. Stop doing criminal activities. It's not harassing either. This woman needs to do a study course on what harassment actually is because she has no understanding of what harassment is. She wants to exclude Clayton Echard. Um, he's there to impeach petitioner's credibility. Well, your credibility is at stake here. They involve different facts, parties, and legal issues. It contains no finding of false abuse allegations. It bears no relation to whether petitioner continues to fear respondent. Testimony therefore should be excluded, is her opinion. Like I said, I think Mata saying that she does not believe that she was ever pregnant, actually means that she does not believe Owens' allegation of SA that she said Eckert did when he, in my opinion, did not. Procedural background, um, she talks about she's like, "I have restraining orders against everybody, judge, so can you just please give me this?" I'd be like, "Ma'am, why you have so many restraining orders?" I mean, because just the fact that you admit that you have all these restraining orders makes it look like you have a pattern here. No Arizona ruling has ever found that petitioner fabricated or falsified abuse allegations, and no court has deemed her fear unreasonable. I don't know how true that statement is. Claims she made false abusive claims. Well, you did make false abuse claims because you said he raped you. Um, no identical pattern. She is taking identical she's thinking that it means identical cases, not behavioral patterns. You She says, "Petitioner never alleged that Eckert engaged in physical violence, whereas her allegations against Maricini do." That is a lie right there, and it's perjury. A knowingly false statement. You knew when you wrote this that you had alleged that Eckert engaged in physical violence because you accused him of sticking it in without your consent. So, go fuck yourself with that one because you're lying once again. Says it's irrelevant. Everything she does is irrelevant. And Eckerd can testify if he saw stuff that happened in his case. He knows about things in his case that relate to Maricini because it was yours and Egger's case that brought a lot of this to light. Lack of personal knowledge, nobody is there to testify about anything other than what they know. I didn't even meet him until 2024. Well, guess what? 2024 is between 2020 and 2025. And guess when Eckert's case was in between that time period? Your renewal is for things that you are saying Maricini did between those years. So, things happening at Clayton's hearing, I think Clayton is a relevant witness. She says it's retaliatory. Everybody that speaks against her is retaliatory. No. Bias, maybe. Improper character evidence, uh, jurisdictional, everybody cannot come to this hearing because they weren't subpoenaed correctly or they're out of state witnesses, which I don't think you would even have to subpoena these men. Let's see. She lists Gillespie again. I don't know why. It's not a retrial of original abuse allegations. It should be. It should be. And I think Omar needs to file that again. Um, protective order record contradicts witness description. Reasonable cause to believe defendant may commit an act of domestic violence. None were contested, modified, or vacated. So, if nobody contested these and fought against them, then how can there be any findings? They're just taking what you said as true, and they didn't even fight because they just wanted to get rid of your crazy ass? One remains in full force and effect. Retaliatory misuse of protection orders, yep. Well, that's what he thinks with evidence that he has now. He has knows nothing about me and Maricini, blah, 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 blah. Improper character evidence and hearsay? What hearsay? I don't know what hearsay he would have. She thinks it's going to do that. She requests this order to exclude in its entirety any testimony, declaration, or appearance. Preclude respondent on counsel from referring to any alleged false pregnancy, forged ultrasound, or misuse of protection orders. No, that's not gonna be, precluded. Nobody's misrepresenting any Arizona proceedings, and nobody is doing anything for the court. Alright, this is Joan. Um, they talk about her stuff is irrelevant because it was from back then, but it goes to your credibility, Laura. And then she wants to exclude irrelevant and improper exhibit. Under advisement ruling from Superior Court of Arizona issued by Julie Mata, she said that this would mislead the court and improperly expand this hearing beyond the scope. No, it goes to your credibility and that you have been found to lie about things. It's very relevant. The criminal indictment. It's unrelated to the renewal and would cause undue prejudice and confusion. No, it's not confusing the judge. And it shows that you're a liar, liar, pants on fire, and you're being charged criminally. That's what it proves, is you're being charged criminally. It doesn't say that you're guilty, it just says they had probable cause and you were indicted by a grand jury. Correspondence from Dr. John Ching Kai Chan and Rebecca Yi, purported medical correspondence predating the restraining order. Um, she says that it wasn't part of the court record. Well, yeah, but you still used it. And guess what? We found out those things in 2024 were false because you said that you didn't have ovary removals and cancer. But here, these documents that were sent by you that have been forensically analyzed say that this is what happened. So you were lying then or you're lying now. And an ultrasound would fix that right up. But I know that you're allergic to ultrasounds. She says that the police report and photograph of the investigating officers lacks authenticity. Well, it doesn't if it's been forensically analyzed. And I don't know why it's cumulative. Do you know what cumulative means? Um, Image of Laura with redness around her face, particularly her right eye. It's undated and unauthenticated photograph offered without foundation. Well, he has to lay the foundation before this can be entered into evidence, and Omar will he will get to the foundation before he moves Exhibit 106 into evidence, and it does. That picture to me does have something to do with the renewal because that was the basis of you wanting it back then, and basically, if that's what he did to you back then, and that's what your fear stems from now, that you're afraid he's going to do whatever you say he did back then, that picture is very relevant, in my opinion, because that's we're looking at somebody who supposedly did something to you, and this is what he did to you supposedly, and this is why you still want the restraining order because you don't want him to do that stuff to you again. So, I think the picture is relevant. The image okay, yeah, unauthenticated. No, it's not unauthenticated. There's apparently some metadata with it. The digital forensic report, she says it was unsupervised. Nobody cares if it was unsupervised or if it was privately commissioned, and it doesn't have to be a part of the previous record because you could say that the reason you want the renewal wasn't a part of any prior DVRO record. Like, Maricini going to court, well, that wasn't a part of the prior, record of the DVRO record, but here you are bringing it up. So, your arguments don't make sense. That's why you need an actual lawyer. She says that the order against Clayton Echard and all of that doesn't matter. She says the subpoena issued by the Superior Court of Arizona to Michael Maricini, um, with Randy Sue Pollock says this document purports to be an Arizona subpoena for respondent's appearance. It was never domesticated through any California court as required by the Uniform Interstate Depositions and Discovery Act and therefore has no legal effect in this jurisdiction. Correspondent remains subject to the Cleats restraining order issued by this court on September 11th, 2020, renewed through July 10th, 2025, and could not lawfully appear or testify in any out-of-state proceeding involving petitioner without prior authorization from this court. No such permission was ever sought or granted. kinda like you in your criminal case to appear for this case. Respondent, Arizona counsel Randy Supalik confirmed in writing, yeah, well, things changed, that he will not be testifying. The inclusion of this unenforceable and non-domesticated subpoena therefore creates a material misleading impression that respondent's appearance was judicially compelled when all parties knew he lacked both a valid subpoena and jurisdictional authority to attend. Oh, and she cited Megan Fox's YouTube video, from June 2024 with the timestamp, knew he wasn't going to testify. Well, he found that out once he was already there. He didn't know that before coming. The exhibit interjects collateral Arizona procedural issues wholly unrelated to petitioner presently harbors a reasonable apprehension of further abuse. Its admission would mislead the court, confuse the issues, and cause undue prejudice and harassment of protected party. No, this is very relevant, and it's not gonna confuse the issues or mislead the court because this is the defense of why he went to the court hearing. So, yeah, he gets to use this to say, "This is why I was there." It wasn't to harass her. And she says, "If the court determines to admit the exhibit, petitioner requests that it be received solely for the limited purpose of showing that respondent's travel to Arizona was voluntarily and not compelled by any valid subpoena, as confirmed by his counsel's written statement and his subsequent public admission." It would be admitted to show that this is why he showed up. Because how is Mike to know that it's not a valid subpoena? Like, he just sees subpoena on it. Why would she think that it's not valid? Why would he think that? He doesn't know. Um, Complaint against Greg, the order of protection against Greg. She says that, it's no bearing on the renewal. It's unrelated. It's just to attack Owens' character. Unauthenticated photograph or record predating issuance of DVR by 2 years is irrelevant. No, it just shows you lie. You like to lie, and that you're lying once again to get this renewal. She says these text messages have nothing to do with it because they predate the restraining order and they're unauthenticated. No, they're not unauthenticated. And remote and inflammatory. Well, that's because you're the one who wrote them. How is it inflammatory? You're such a liar. Uh, Post of Owens at a KGO celebration for Ron Owens. No connection to the abuse. Well, it does if you say you were injured and things like that during any of these times. Deposition of Owens in Eckerd paternity case regarding Dr. Chan oophorectomy. Just deposition transcript from separate Arizona litigation, hearsay related to Maricini. It's not unrelated to Maricini because the oophorectomy in Dr. Chan happened in the Maricini case. They asked you about it in the Eckerd case, and you admitted that you didn't have an oophorectomy. Equestrian rider reports, irrelevant to abuse or fear. Petition, order protection. Single text from 9 years ago, predating issuance of restraining order. I don't think she can't say unauthenticated because all the text messages have been authenticated, and she can authenticate them because she could say, "Yes, I sent this," or, "No, I didn't send this," and then the forensic analysis is gonna say, "Well, it said it came from her, and here's why." So, inauth authenticity is not a issue here. And then she talks about the her email or the email from Laura's attorney, David Gingras, to respondent dated May 8th, 2024. She says respondent characterizes this email as evidence the petitioner sought direct communication in violation of the current restraining order. The claim is legally and factually incorrect. The restraining order protection protects petitioner and restrains respondent. It imposes no reciprocal prohibition on petitioner. Nobody said that you violated a restraining order. Even if petitioner had initiated contact, such contact would not constitute a violation of her own protective order. Well, I don't think you have a protective order against on you, except for with Clayton. I don't think that you got any other cases. But it's not a violation. You reaching out or initiating contact is not a violation of the protective order. You are setting up Maricini to violate the protective order. His protective order is what we're saying. You are making it where he violates it because he can't have contact with you. And that's why I gave the example of there are people who have restraining orders out, and then the person who has the restraining order out invites their little boyfriend or girlfriend that they have the restraining order against back over to their house. They get caught over there, even though the person who has the restraining order told them they could come over. They are not allowed to come over because the court said no, and it doesn't matter what Owens wants. The court says no, and until the court says yes, you cannot have contact with them. Says email was authored solely by petitioner's counsel, David Gingras, who has confirmed that he misunderstood petitioner's instructions and sent the message without her consent. This is malpractice. Your attorney is speaking on behalf of you. Gingras, when he's writing documents and things like that and acting as an attorney, is not acting in his own personal capacity as David Gingras. He is acting as you, basically. So if he says something and says that you did it, it's basically you saying that same thing because it's on behalf of you. And your attorney cannot do things without your consent. You shouldn't do things without the attorney's consent, but you do, and you can. But an attorney cannot just be filing things and doing things without your permission. And Gingras is always one to say, "Oh, I got Laura's permission. Oh, I got Laura's permission." So you may say that that was him saying that, not me. That's not what I said, but that is what your attorney said on behalf of you as your attorney. Petitioner never intended or authorized any communication with respondent, and Mr. Gingras is prepared to testify so. The document is therefore irrelevant, misleading, and prejudicial. No, it is what it is. It's what it said. And yeah, sure, love to hear what the miscommunication was. That you would speak with Maricini and ask him questions. I don't know how you misconstrue that, but okay. She says that the email to the media tip line regarding the Eckerd paternity has no I don't know that it goes to things about to her wanting to keep things private and stuff like that. Um, but and that one probably doesn't really have anything to do with Maricini. Um, Criminal discovery filing is irrelevant. Um, I don't know if it is or isn't. Text messages about inpatient psychiatric therapy. She says it's out of the scope of this proceeding, prejudicial and privileged. It's not privileged because you made it a part of the court filing. You are the one who brought it into the spotlight. And why is it prejudicial that you sought treatment? The only reason it would be prejudicial is if you lied about it. And psychotherapist patient privilege, you waived that when you brought it up. And the psychotherapist isn't the one coming to talk about it. It's you that talked about it. So it's not privileged under patient privilege because it's not the doctor stating these things. It was you. The declaration, she says it's redundant and cumulative. Findings from Judge Mata, petition to the court, um, has nothing, in the Eckerd case, has nothing to do with this one, and so that is it. But lots of lies and misstatements from Laura Owens in here, and misrepresenting facts. So, I know this was a long one, but those are all the documents that we have. I am going to make a video about Gingras's email that he sent to me. Um, Make sure you liked and subscribed. Thank you for sticking with me. If you did, like I said, I'm going to try to timestamp in case you missed parts and you want to just go back and listen to that particular part. And I will keep you up to date. And we'll see what happens tomorrow. And if this is going to be a continued saga. But y'all have a good evening. Get some good rest, and I will see you later. Bye.
I maybe be angry, jealous, or in love. Make sure outsiders don't ruin the reputation and reveal our secrets. They need to be stopped, or the truth will come out. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time and a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity. The motive, the means, and the opportunity. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time and a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity.